online in time, so we're going to start now. We're still waiting for a few more people, but I want to respect the fact that you guys are all on by 10 a.m. Thanks for joining us today for our annual California labor law update. We have online today, we have clients, we have friends of the firm, we have some provisor members that have joined us. So welcome to everybody. We are recording this. And after the webinar is over, we'll be taking the recording and putting it up on a private YouTube channel where all of our webinars are. And we'll be sending out the slides to everybody. And if you want to watch the webinar again or get certain pieces from the slides, we'll be able to do that. This labor law update was created by myself and Brent Yarkin. Brent's online today too. Brent heads up our HR consulting practice, and the two of us put this together. As always, we have a disclaimer that the content of this webinar is provided solely for informational purposes. The information should not be relied on as a substitute for legal, accounting, tax, or other professional advice. That's what our lawyers ask us to do. The source material for this webinar comes from a number of places. First, two of the three law firms that we recommend our clients a lot, Karen Gabler at Light Gabler, which is an employment law firm headquartered in Camarillo, and Sherry Shavitz, who heads up the employment law practice at Tharp & Howell in Sherman Oaks. In addition, Cal Chambers, HR California, had an employer update in November with the labor laws. Think HR's labor law update in November, and the PIRA Woodland Hills chapter had a labor law update also. I've also received information from a number of the law firms, but we've relied on these. So we'll move forward. The agenda today is really to go over all the new requirements from employers in California, starting with parental leave, ban the box regarding employment applications, no more salary questions regarding employment applications, the new Immigrant Workers Act in California. Since we're now a sanctuary state, there's some new rules that was put into place. There's three laws, two Senate bills, one Assembly bill dealing with gender identity and transgender rights. There's also a change in labor law enforcement we're going to talk about, the minimum wage increases in various cities, and then lastly, updated posters, pamphlets, and notices. And those have to do with labor laws and things that were passed. The last item, wage statement violations, we're going to discuss what has to be on a wage statement and a court case that is in play right now. There's no resolution to it, but it's something that's very, very important for employers to be aware of. So let's start out with the new Parental Leave Act. You probably have heard a little bit about it. The new Parental Leave Act affects employers with 20 or more employees within a 75-mile radius of your headquarters. So for example, we have a client in Newbury Park, and I see he's online right now, and they have a location in Orange County. Combined, they have more than 20 people. The question is whether the Orange County location is 75 miles away from the Newbury Park location. If it is, then the Parental Leave Act will not affect them at either location. But on the other hand, if you have 20 to 49 employees and you have more than one location, but it's all within 75 miles, then it will affect you. Now, this law only takes place for companies with 20 to 49 people, because above 50 and above, the FMLA federal law falls into place. The question which has come up is, how do you count employees? And in this law, you count full-time and part-time. So whether you have 15 full-time and 6 part-time, you get to 21, then it's 20 or more. Counting employees with the various labor laws are very important, and I'll make a little announcement that the way you count employees for the Affordable Care Act, for COBRA, for pregnancy disability leave, for FMLA, and for parent family leave, everything is different. We did a seminar, a webinar last year and sent out a sheet to everybody talking about how do you count employees? Do you count part-timers as a half a person, or do you count them as one, as in the new Parental Leave Act, or under the ACA, do you have to count it based on hours to get to full-time, which is 30 or more hours? So if you're not sure how to count for various requirements, if you let me know or your contact at Really Great Employee Benefits, we'll send you out this in an email that shows you how to count employees. So the new Parent Leave Act, you get 12 weeks of unpaid leave to bond within 1 year of birth, adoption, or foster care placement. It says within 1 year. So you don't have to take it when the baby's born or when you adopt. You can take it 6 months later or what have you. You don't have to take it in one lump sum either. It only affects employees that have worked for you for 12 months and have 1,250 hours during that 12-month period, basically. An employee may use accrued vacation, paid sick time, or PTO to be paid because this Parent Leave Act is an unpaid leave. So you have to give them 12 weeks, up to 12 weeks. You have to reinstate them. However, it's unpaid. So you could say, they could decide to use accrued vacation or paid sick time or what have you until their leave until that runs out. The next item is important, and it's a little bit of a question mark. If you have group health insurance, you have to maintain the employee on leave during the time they're on leave. Now, since it's an unpaid leave, you can't take the employee portion of the health insurance out of their paycheck. Because theoretically, if they're not using vacation or paid sick time or PTO, then you don't have a paycheck to take the employee portion out. So the employer has to maintain group health coverage. So for example, if the employer pays 80% of a plan and the employee pays 20%, you still have to pay that 80%. You have to collect that 20% from the employee. The question is, what if they don't pay you? If they don't pay you, you're able to terminate them from the plan, in which case they would have the option of CalCOBRA or COBRA. I guess it would be COBRA since there's 20 or more. It falls under federal COBRA. If they take COBRA, great. Then the question becomes, after the unpaid leave of 12 weeks and they come back and join you, the question is, what happens? If you've terminated them from their health insurance, you can't bring them on as a new hire, and the problem is that the carriers right now, if you terminate somebody, they can't rejoin the plan until the next open enrollment. So this is the question mark. The question mark is, what happens if somebody doesn't pay, you terminate them, and then they come back on? They either have to stay on COBRA for a while. It's also not a qualifying event under the IRS code to buy individual insurance. So if they don't take COBRA, they could be without health insurance until your next open enrollment period. I've checked with a couple of sources, including the National Association of Health Underwriters, which is our trade association. I've checked with SHRM, the Society of Human Resource Management, and also ThinkHR, and there's no clear-cut answer to this yet. So this is an up-in-the-air, unintended consequence that could happen. In California, there's also paid family leave and state disability, and there's some minor changes to that in the new year. The first change is that the benefit, which used to be 60% of wages, will now become 70%. And then for paid family leave, the waiting period is only 7 days. The waiting period used to be 7 days for SDI and PFL, but they're removing the 7-day waiting period for PFL. Paid family leave, just so you know, it is something that comes out of their paychecks. They get a certain amount of income when they're on paid family leave. And they could use paid family leave for the previous parental leave. Since the parental leave, the new law is unpaid, and this is paid, they could use this. Employees eligible will be able to take it. So these two will work hand in hand. The next item is ban the box, which I think is all over the newspapers or has been. And that basically is if you have 5 or more employees, you cannot ask any criminal history or on job applications anymore. So you can't ask, have you been convicted of a crime? And have you been convicted of a felony? And you can't consider criminal history before you hire someone, unless you offer them a conditional offer of employment. And this gets pretty complicated. If you offer a conditional offer of employment, subject to a background check and criminal check, you can seek certain criminal history. You can make a preliminary decision not to hire someone because of that, but you have to notify the applicant in writing. The applicant then has to have an opportunity to respond. There's a specific timeline and process involved. And once you make your final decision, must consider applicant's info before the final decision is made. And then if you deny employment, you've got to give them a written notice as to why you are denying them employment. It's complicated because if you do a criminal background check and then you have to rescind a conditional offer of employment, it's a problem because it also says that you can't consider criminal history as before you offer that conditional offer of employment. This is a kind of an up in the air thing. We have to see how it's going to work. The question came up recently in a meeting I was at about financial people. So there is an exception in ban the box if you have a financial position, for example, an accounting person, a controller, a VP of finance. If you're in the securities industry or banking industry, there are some exclusions for that. So to be aware of that. At the same time, you can't ask salary questions. Now, one thing I didn't say about ban the box is the reason that the California legislature said that this was important is that they believe there's a number of cases where someone was convicted of a crime 10 years ago or 15 years ago, and an employer has multiple candidates and just ruled them out automatically. And in a discussion group I'm in through the Society of Human Resource Management, that was a question that was asked today by somebody out of state who said, I have an applicant. They were convicted of a felony 11 years ago, and are we able to not hire them because of that? Now, they're not in California, and it wasn't a financial position, but, those things happen. When you have equal candidates and one was arrested and convicted, human nature is let's not hire that person. So there's also no more salary questions. So AB 168 says you can't ask on an application what their compensation and benefits were before. The new law prohibits employers from relying on that salary history or using it as a factor to hire someone or not. So the bottom line is what the state of California is saying is we have to interview people, hire people, tell them what we're going to pay them, and not consider past employment or what have you. The reason is that there's a belief in the California legislature and probably nationally that women are not being paid equally to men historically. It looks like it's 86% of what men get paid on average, women get paid in this country. And therefore, if you ask somebody what their salary or what their hourly was, then you can give them a little increase when other people in your company might be much higher. So that's what prompted this. Now, if the employee asks for the pay scale for the position, you're supposed to give them the pay scale. So if we have a position, we just hired somebody recently at our front desk, and the position's $15 to $20 an hour, and if when we interviewed this person they said, what's your pay scale, we would have to tell them the pay scale. So that's basically it. One thing I didn't mention was if anybody has any questions, there's a chat box in the bottom. I don't always see it, but I'll look for it on occasion, and if you have a question, we'll try to answer that. AB 450 is the new Immigrant Workers Protection Act, and this falls in line with California being a sanctuary state now and protecting immigrant workers. So it basically says that an employer cannot permit federal immigration enforcement agents, basically people from ICE, to come onto their business unless they have a warrant or a subpoena. So if they have a warrant, then they can come on your property. If they ask for employee records, they have to have either a warrant or a subpoena. Violations are $2,000 to $5,000 for the first offense, to $5,000 to $10,000 for subsequent violations. So that's very important. If you are notified that there is going to be a immigrant ICE coming onto your property, you also have to let your employees know. So under AB 450, there's something regarding Form I-9 inspections, which basically says that if you get a notice that the Federal Immigration Agency is going to inspect your Form I-9 or other employment records or come on your property, you have to take that notice of inspection and post it within 72 hours of receiving it in the place you normally would post things. The notice has to contain specific information about the inspection in the language normally used to communicate employment-related information. Now, we'll talk about this a little bit later, but in California, there are 17 languages that are considered languages that you may have to post things with, notices, handbooks, any kind of notice to give to employees if more than 10% of your workforce speaks that language as their primary language. And we have a client in Orange County that has half of their employees are from Vietnam and primarily speak Vietnamese. It's a situation where they're going to have to provide every notice they give to employees in two languages, English and Vietnamese. They have to get a poster in Vietnamese. So anyway, in this case, the employers must comply with this posting requirement beginning January 1st. However, we're not going to have a model posting notice until July 1st. So there's going to be a model posting notice that comes out, and in addition, you have to post a notice of inspection that that ICE sends you. So that's important to know. As a follow-up, if after the inspection you're notified that an employee is not working in this country, the documentation they gave you is not correct, you have to provide a copy of the notice of inspection to that affected employee. You have to give that employee a copy of the inspection results and a written notice of the employer's and employee's obligations, and that must be done within 72 hours of receiving the results, and an affected employee is one identified by the inspection results as potentially lacking work authorization or having document deficiencies. This comes up all the time now, but not through an inspection. But the federal government will send the notice to an employer that says, employee John Doe with this Social Security number, there's a problem with that Social Security number, it doesn't match the name. That happens a lot now if you're over 50 employees and you have to do Section 56 reporting and hand out 1095-C forms to your employees, letting them know that you offer health insurance under the Affordable Care Act. When that information is uploaded electronically to the IRS, it kicks out things immediately. We have a client with 150 people in the LA area that happens to be a restaurant group, and last year we had about 12 kickbacks from the IRS saying these aren't valid. So you have certain requirements under this new law. You have to tell them, here's the notice of inspection, here's the information, here's how you correct it. And I don't know if it's any different than if we just notified directly, but right now, you can't fire someone if their documents come back suspicious. You have to provide them, I believe it's 90 days, but don't count on that being correct. My memory is not as good as it was when I was 25. But I believe it's 90 days. They have to come back with proper documentation, and then you can make a decision to keep them on or not. So the next three items are all about transgender rights. So in the first line, I should have put sexual harassment prevention training. Right now, if you have 50 or more employees federally, you have to have sexual harassment training. In California, under SB 396, you have to include in the course gender identity, gender expression, sexual orientation, information about harassment from those three things. The harassment prevention has to be every 2 years, and the training content must include practical examples intended to address these types of harassment. Employers are required to display a poster on transgender rights. So let me talk about that poster. The poster came out in October or so, and we put it up in our lunchroom. And then when we got our annual posters, which we get from Cal Chamber, but usually you have posters that have state and federal notices in an annual poster. The new Transgender Rights notice is in that poster. So if you've updated your poster this year, you should go and check it. But it was a SB 396, and it's dated, I think, November 2017. It should be in there. So the question is, how do you handle sexual harassment training if you have 50 or more employees? Sometimes you do it with an HR consultant. Sometimes you can do it online with certain organizations. We recommend our clients, and we promote Think HR. They have training courses. They also have sexual harassment training, and they will update their California course to include this. I'm not sure if it's updated yet, but it will be. So the second item on transgender and gender identity is SB 179, and this has to do with gender identity in documents. In California now, you can become, on your birth certificates and driver's licenses and ID cards, either male, female, or non-binary. And the options apply to state-issued identification cards, birth certificates, driver's licenses. The law won't be effective until September 1 for birth certificates and driver's license a year from now. But be aware that you may be receiving birth certificates or driver's licenses or ID cards when you do your Form I-9s that may say non-binary. I'm going to suggest that you reevaluate your employment applications, not your applications, but once you hire somebody, to provide them the option of male, female, or non-binary. And the issue with the state law is that it may not equate to the federal law. And what I mean by that is the Form I-9 right now doesn't have a non-binary option. It's either male, female. So in the next 12 months, that's going to have to be adjudicated in some way, or there's got to be some kind of ruling that says if you do a Form I-9 after September or after January of next year, and it says non-binary, how do you fill out the Form I-9? Or what documents do you use? So that's still a question up in the clouds, not having an answer yet. The other thing I want to mention about gender identity here is there was a law that came into existence March 1 of 2017, last March, that talks about bathrooms. And it talks about gender-neutral bathrooms if the bathroom is a one-stall bathroom with a lock on it. Usually you see that in restaurants. Peter, who's on the webinar, one of our people, said he went to a restaurant yesterday, pizza restaurant, and their bathroom said male or female, but when you went into it, it was just one stall, you closed the door, you locked it. As of March 1 of last year, those have to be gender neutral. And also individual bathrooms in employer locations. Brent and I went to see a company in South Central LA a couple weeks ago, a manufacturing firm, and at the end of the meeting, I needed to use the restroom before I headed back to the valley. I walked into the restroom, it said male, and it was just one door. I locked it, did what I had to do, came out, and said to the owner, "Are you unaware of the new law from March 1 that says these have to be gender neutral?" And he had no idea. So just to be aware, to remind you again that if you have any kind of restroom facilities that only have one stall and has a lock on the door, but they have to be gender neutral. And as we continue with gender identity and gender neutrality, under the Fair Employment and Housing Act, FEHA, any kind of discrimination language, harassment language, pregnancy disability language, medical leave language needs to be now gender neutral. So that would include handbooks and notices. You should be changing your he or she to the person or the employee. You can also grammatically use they or their. even if it's a single person, which I double-checked on Grammarly.com to make sure that was acceptable. So just remember that any kind of regulations, all notices now need to be gender neutral or should be gender neutral. And if an employee requests a certain gender, if an employee comes to you and says, you know, I want to be called as a he or a she or something else, that under the 2017 law you have to use the identity that they identify and tell you about. Now, that may seem like, well, you know, that's not going to happen, but we actually have a client in Culver City with about 35 people, and one of their people is changing genders right now. We also have one out in Simi Valley, too, as a matter of fact, and so they have to deal with that pronoun. So be aware of that. I would suggest that you review your employee handbooks, any employee notices you give, maybe a notice of HIPAA privacy practices notice, open enrollment material, if you have anything, any memos, whatever, to basically move away from the gender-specific language. And again, I'm not providing opinion as to whether I think that's right or wrong. It's just that's the law. We need to follow it. The next one is labor enforcement, and it falls into a couple categories. But the Labor Commissioner's Office now has the authority to enforce wage and hour laws, even if they haven't done an investigation yet, even if there hasn't been a ruling yet. They can investigate an employer even without a complaint. If they believe that, or they suspect that there's discrimination against a worker or retaliation against a worker for saying something, you have to be aware of that. Now, last year, the DFEH received 17,000 complaints of discrimination by employees. I'm sorry, I said last year, it was 2016. Of those, 21% were for retaliation, and 80% was for some form of discrimination, race, creed, color, gender, what have you. So now, if the DFEH has a complaint and they haven't investigated yet, they could stop the employer from doing certain things, and you're not able to fire somebody for retaliation, et cetera, et cetera. So be aware of that. The court order, the DFEH and labor commissioner can get a court order showing reasonable cause that there's some discrimination going on or retaliation going on. If they get the court order, you're going to have to follow that court order, and it basically has to show reasonable cause, which is not the same kind of burden of proof in the actual complaint itself. So if an employee files a complaint of discrimination with the DFEH or EEOC, and the DFEH believes that under reasonable cause it might really exist, they can go get a court order immediately and stop you from doing certain things, even though they haven't done an investigation yet, haven't cleared the case yet, and what have you. I think last year they only cleared 1,100 cases for about $10 million. If you were on our webinar a couple months ago about DFEH and EEOC investigations, it was about 1,100 that were settled. So now this new law, SB 306, says, okay, we know you're backed up, we know you can't investigate everything quickly, but if you have a reasonable cause, you can go ahead and get a court order. So that's the new law. Minimum wage. So let's talk about minimum wage. I have two slides here because the California minimum wage is different than the Los Angeles minimum wage. The California minimum wage kicks off January 1, but in the city of LA, it's July 1. So these rates are current rates that will be in effect July 1, 2018, 19, etc. If you have 25 or under employees, and if you have 26 and over employees. Malibu is also July 1. It looks like Malibu corresponds exactly with LA. But if you notice, Oakland is January 1, and it's higher than the LA and Malibu rates. So a little caveat on LA. if you're not located in Los Angeles, so let's say you're located in Burbank, Pasadena, Glendale, Oak Park, Ventura County, Westlake Village or whatever, but you have employees that travel into the city of LA and work at least 2 hours a week, they have to be paid the LA minimum wage. This also pertains to sick pay. The Sick Leave Act in Los Angeles is 48 hours, where California is 24 hours. So if you have a worker that's working at least 2 hours in LA, then they fall under the City of LA sick leave accrual rules as well as minimum wage. Now, it doesn't affect a lot of people on minimum wage, but it does affect a lot of people on the sick leave. And so the question is, if you have 20 employees and 5 of them are traveling to LA to do work, and you accruing sick leave on your payroll system, how do you separate out those people that are going to LA? And if they don't go to LA every week, I mean, it's a very complicated situation. And we were asked by one client, what should they do? And we suggested that they just use the LA sick leave to be safe, rather than to have somebody who comes into LA, doesn't get the extra 48, extra 24 hours, and then sues them under PAGA. So that's just something that I would discuss with your labor attorney, but it is an issue. The next slide talks about Pasadena, San Francisco, and Santa Monica. Now, San Francisco has the same 2 hours a week rule that LA has. So if you're in Oakland or Marin County and you have workers that come into San Francisco, you also have that to deal with. Okay, we'll move on. We're going to talk now about 10 myths of posters. And the reason we're going to talk about this is that recently, Brent and Peter and I have been to various companies where we had poster issues. One company, which we talked to this morning, which is just joining us for some HR services, their labor poster was dated 2004. We have another client, actually a prospect, which is now a client, in Sherman Oaks, that had a Form I-9 form from 1989, when the form was updated twice last year. So we decided to add some labor law poster myths and talk about them. The first is that people believe that ignoring poster laws carries no risk. And I want to tell you that that's not true. First, when it comes to fines, the amount of fines on the federal level can be as much as $33,000 per location for posting violations. On a state and local level, the fines can be $100 to $1,000 per violation. And what employers will say, well, there's no poster police, so we don't have to worry about it. Well, in reality, that's true. There's no or federal or state agency that goes in and just inspects posters, but you might get inspected for something else. It might be a Form I-9 audit. It might be an OSHA inspection. It might be a Department of Labor audit about your ERISA practices. It might be an Office of Civil Rights audit regarding your HIPAA privacy practices. As people that are clients of ours know, the Department of Labor hired 16,000 new auditors about 2 years ago to audit every employer in the country. And they will end up basically, eventually, auditing everyone. And, you know, one of the first things they ask for is, show me your I-9 file, and they look at posters. So if your posters aren't up to date, now in Los Angeles, if your company's in Los Angeles, you have the federal and state posters, as well as the City of LA poster. There's 2 posters in the City of LA. There's a minimum wage poster and there's a fair chance poster. So be aware of that. The second myth, which we hear a lot, are my workers' comp provider gives me everything I need and I use their posters. And the work comp people, insurance carriers or insurance agencies, that do work comp, they'll give you an OSHA safety poster, but they may not give you all the posters you need. And that kind of is an issue. There's no one-stop shop for getting the government posters, and I say that because, and we have clients that are in multiple states, And ourselves, we actually have a client in Utah. So when she moved to Utah and we decided to have her be a telecommuting employee, we had to go and get all the posters that are required in Utah and send it to her to post in her office at her house because we had to follow those rules. So in California, there's 21 notices, employee notices or posters, that are created by 7 different agencies. And in the country, there's 370 mandatory poster announcements with 175 different agencies. So we have clients that have locations in California, Arizona, Nevada, California, North Carolina, California, New York. So you have to make sure that you're following the poster requirements in the states that you operate. Posters only need to be updated once a year. That's another myth. And it's a myth because usually most employers will get an automatic renewal from one of a number of sources. I said that we get ours through Cal Chamber. It arrived the last week in December. We posted it on the wall. At our first office meeting of the year, we said we have a new poster up. Please look at it. But that Transgender Rights notice came out in November, and that had to be posted. So we had to post that in November, and we did. The minimum wage law in Los Angeles changes every year in July. So you have to post that every July. So you have to be aware of what you need to post and make sure that you're doing it timely. What you don't want is an employee to find out through a source. It might be an attorney. It might be another friend of theirs that there's a poster they're not seeing, and then they end up suing, and that would pose a problem. Posting in foreign languages is optional. That's what people think, and the answer, of course, is no. I already talked about foreign languages, and as I said, in California, 17 languages might be applicable. In some states, you have to post in English and Spanish, even if you don't have Spanish-speaking people. So there's 22 states and Washington, D.C., but all your postings have to be in English and Spanish, regardless of your workforce demographics. The next one is only federal and state agency issue postings. We already covered that because I just mentioned that the City of LA has 2 posters that have to be up. And the next one is that federal contractor posting requirements don't apply to me. Companies that do business with the federal government or are audited by the federal government in certain places have to meet the federal contractor posting requirements. Financial institutions, technology companies, nonprofit organizations that may get grants from federal agencies, auto dealers, some retailers, restaurants, they have different notices. And if you have any government contracts that are federal funded, or if you're a subcontractor on a federal funded government contract, you may have to post certain extra notices. These include a federal minimum wage notice for contractors, a paid sick leave poster for contractors, a notice of employee rights under the National Labor Relations Act, a notice to employees working on government contracts. It's called SCA Walsh-Healy Bill, and a notice of employees working on federal or federally financed construction projects, which is a Davis-Bacon law. So if you're a contractor and you do federal work, it's going to apply to you. If you are working on any kind of government contracts, it applies to you. National Labor Relations Act, I believe that's in the regular poster that we get every year, but I'm not 100% sure. If you don't comply with the federal poster requirements, you could be denied a future contract. They can also suspend payments or contracts in the middle of a project, so that's kind of important. The next myth is posting laws that don't affect remote workers. I guess we covered this already, and that is that any workers that are remote in a different location, you have to post. So as I mentioned, we have somebody online today that's had a location in Newbury Park and also in Orange County. They have to have 2 sets of posters and notices, one in each location. We have a client in Santa Monica. I don't see her on, but she's usually on, and I chatted with her yesterday actually about this. They have an LA operation, a Santa Monica operation, in their main building. They have an annex building across the street, and they have a New York location. So the question was, do I need to put my posters up in both locations in Santa Monica? And my question was, do the workers go into the headquarters building every day, and do they pass an area that has a poster? And the answer was no. And therefore I said, well, then you need to get two different sets of posters. And then New York has their own set of posters. Poster requirements are the same for all types of businesses. That's another myth. And I'll just give you a couple items. In the restaurant industry, there are certain notices that have to be posted that other employers don't. If you're in the healthcare field, there's 15 additional notices, including radiation notices, notices regarding patient rights, depending on the facility, whether it's an imaging lab or a doctor's office or what have you, they have special notices themselves. Restaurants have certain notices. There's a notice regarding how tipped employees get paid. There's also a choking assistance notice, a poster about if someone's choking in the restaurant, and CPR procedures in case someone's choking or having a heart attack, and also information about serving alcohol to minors if you have a bar. So depending on your business, you have to make sure you have the right posters. We only need to say one set of posters. I already covered that. But here's one that I was really unaware of. Posting regulations don't affect job applicants. And the answer to that is untrue. That a job applicant, if they're coming in for an interview, there's 6 mandatory federal postings. 4 of them must be displayed in areas where employees and applicants can view them. And those notices are, one is an EEOC notice, Equal Opportunity Notice. One is a Veterans Notice, the USERRA, USERRA Notice. That's in the annual posters that go up. Employment Polygraph Protection Act, that's in the annual notices too. And FMLA, if you're over 50 employees. So if you have a poster in your lunchroom, these notices are already there. But if you have an applicant that's not going past the lunchroom or past the coffee area or wherever you post it, then you need to have this posted. And if you don't, or either posted or you have to hand them those notices. So let's talk about updated posters, pamphlets, and notices. I mentioned the Transgender Rights Notice now. For 2018, there's a new Cal OSHA poster update. If you have 25 or more employees, the rights of victims of domestic violence, sexual assault, and stalking, there was a new notice July 1, but it has to be given to employees. There's a new, the paid family leave and unemployed insurance pamphlet was updated. State disability pamphlet was updated in July, as was the sexual harassment pamphlet. So I'm saying this because, and we know this because we keep doing HR assessments on clients, which Brent is doing existing clients, and Peter, Brent, and I are working with prospects. When we do an HR assessment, one of the first things we ask them for is their new hire package. We want to review the new hire package and all the notices they give to their new hires. There's 11 notices that have to be given to new hires when you hire them. And I don't want to tell you how many times we'll go into a company and say, show us your new hire package, and we see a Form I-9, we see a W-2 form, W-4 form, but we don't see any of the other notices. And every year, you're supposed to give your employees these notices and have them sign off and acknowledge they've seen them. Now, because we do our HR in the cloud, this coming week, all of our employees will be getting an email that says all of our notices have been updated for the new year. Please go online to the cloud, log in, and e-sign all these notices. So we have proof that we've given out the notices, and we have proof that they've seen them. They're acknowledging that I've seen the notice, and we update every year. So over last weekend, I went and double-checked on our notices and found out that there's some new updated notices. We see this a lot where the notices are dated 10 years ago or 5 years ago, and they've never updated it, and it's important, especially when it comes to gender-neutral language and other items. So let's talk about, lastly, the wage statement violation. I have about 10 minutes left, and hopefully we'll get to all this. These are the items that have to be on a wage statement under Labor Code Section 226. You guys are all probably aware of it if you get paychecks or you're involved in payroll. But the item I want to talk about is that all of these items are supposed to be on a wage statement. And what I want to point out right now is that this right here, Social Security number or ID number, the last 4 digits of a Social Security number, I didn't do that well, have to be on the pay stub or an employee ID number. Full name and address of employer, hourly rate, hours worked, paid sick leave balance. This is why I said if you have workers that work in LA and you have other workers that are in Burbank, Pasadena, Glendale, where you're headquartered, it might be a problem. Inclusive dates, start and end date, etc. There was a employer. Well, let me talk about penalties first. Under the penalties, the damages are the employee gets actual damages or $50 for the initial violation, $100 for subsequent violations, maximum aggregate penalty not to exceed $4,000. So if you have 50 employees, that could be, $2,500 or $5,000, but it's limited to $4,000. That's what you have to give the employees. But now there's employer penalties. And the employer penalties are $250 to $1,000 per employee on top of it. Now, under Labor Code Section 226, it says, this only falls into place if the employer knowing and intentional failure to provide an itemized wage statement. I would bet that 95% of the people on this webinar and 95% of our clients outsource their payroll. You're outsourcing it to a payroll company, whether it be ADP, Paychecks, SurePay, Paycor, whatever, Paycom. You outsource your payroll. And you're making the assumption that the payroll company is doing the right thing. Well, it turns out that in Lopez versus Bryant and Associates, Eduardo Lopez claimed that the employer failed to comply with the wage statement requirements. How would the employee know that you're supposed to have certain things on your pay stubs? But he learned that you had to have the last 4 digits of your Social Security number, and they didn't have it. And he sued under the PAGA law on behalf of 5,776 wage statements that did not contain the last 4 digits of the Social Security number. Bryant claimed it was inadvertent and filed a motion to dismiss because Lopez had not shown that he was injured. I'm injured because you didn't put those 4 digits on. But the law says you got to put those 4 digits on. Now, Bryant believes that because it wasn't intentional, excuse me, and they outsourced their payroll to either Paychecks or ADP, that they were in the clear. Well, under PAGA, if you're not sure what PAGA is, we're going to end up having a webinar in a couple months. It's the Private Attorney General's Act. And any employee can sue a company on behalf of the Attorney General of California, seeking penalties on behalf of the employee and current and former employees. I notice I put himself there. I need to change that and make it gender neutral. I need to learn this new stuff too. If they're successful with a PAGA lawsuit, the employee receives 25% of the settlement, and the state of California receives 75%. Now, a couple months ago when we were talking about discrimination and other things, I talked about a PAGA lawsuit with a company called Timely Industries in Pacoima, where they got sued for a lunch violation, meal break violation, and the employee, and I'll tell you the story quickly. Every day for the last 30 or 40 years, everybody has lunch at the same time in the big lunchroom. All the employees, I want to say there's 40 of them, but I could be off on that. One day a week, Timely Industries brings in lunch for the employees and pays for it. But one employee got bent out of shape, found an attorney, and realized that this person, he or she, was not getting their lunch break within 5 hours. You have to get a meal break within 5 hours of working, the first 5 hours, and it wasn't 5 hours for this one person. They sued under PAGA, and Timely Industries had to settle for $1,200,000. Now, I believe Timely Industries was doing the right thing by their employees to have lunch with everybody and have a big family, but in reality, they were not following the meal break law, and so they got cut, and they got caught rather, and they had to pay this major penalty. So in this Bryant case, they outsourced their payroll. I don't know if it's ADP or Paychex, because when I learned about this, the law firm wouldn't tell me which of it was, but it's one of the two big ones. And those last four digits were not listed. It was XXXX. And the court agreed to dismiss the claim because Bryant said, hey, it was unintentional, we outsourced our payroll. Lopez appealed to the Court of Appeal. The California Court of Appeal reversed the trial court's decision and said, under PAGA, you don't have to show that it was knowing and intentional. And therefore, Lopez and his attorney, or her attorney, could go ahead and sue the company. And the employer is ultimately responsible even if you outsource your payroll. So once I learned about this case, first thing I did was I looked at my paycheck and made sure everything was there. And then I talked to ADP and Paychex and a couple others and said, hey, what's the liability here? And, do you indemnify your employers? And what I got from both companies was basically the following. We provide payroll services on behalf of our clients. We have a written agreement, and it holds us harmless if we make an error. They're supposed to check everything. And so the payroll company is not backing up Bryant, and it's under a PAGA lawsuit now. We don't know what's going to happen yet. When the PAGA lawsuit is settled, we'll find out if Lopez presides or not, prevails or not. And if he does, then there's a new case that's going to affect all of us. So this isn't a labor law per se for 2018, but it's something to be aware of and to watch. On that note, we're at 58 minutes. Boy, this worked out well. And so if anybody has any questions, they can type it in the box in the bottom. I'll try to answer them. We believe that RGEB is your best source for compliance information, so you can contact us with questions about HR, Affordable Care Act, ERISA, HIPAA compliance, city, county, state, federal laws. We're not a law firm, but in some cases we refer our clients to a law firm, labor law firm. I had a client this morning call up and said, I want to make all my drivers independent contractors, and they're going to have their own companies, and they're going to have DBAs, and I know a guy that's doing this in Orange County, and he says it's kosher and it's okay to do, and I'm going, I don't think it is. I think you should talk to a labor attorney, and those kind of things. So if you call us with a question, an issue, we'll try to get an answer for you through ThinkHR, which we use, and some of our clients subscribe to ThinkHR, but we're there for you if you have any questions. On that note, does anybody have a question they want to type in? I do have questions. I'm sorry. I couldn't see them. What if an employee became a new parent in 2017? That's a great question, Jeff Solomon. Of course, Jeff would always ask good questions. The answer is I don't know the answer to that, Jeff, so I have to find that out. But it's a new law, and my guess is that if it's within 1 year of the birth, then the law would apply, and I'll double check on that, okay? 17 birth, and I apologize for not seeing these earlier. They were hidden from me. Ashley Pierce is asking, is the poster for 50 plus? I'm not sure what poster you're talking about. Transgender posters, no, it's for everybody. Transgender posters are for everyone. Westlake Village sick leave is 48 hours. I don't believe so. As far as I know, Michelle, Westlake Village does not have their separate sick leave policy. It's only the city of LA and Santa Monica. Brent, I'll have Brent check for you and get back to you on that. Jeff, I wouldn't put your poster at the front door, but yeah, that's a great question. Yeah, Paul, we're going to get all the slides. As I mentioned when we started, that we will be recording this. We'll get the recording posted onto YouTube on our private channel and the slides, and you'll get a copy of all the slides. Are there any exemptions under EE payroll statement? Not that I'm aware of, Ashley. I'm not sure of that at all. But if you have a specific question, email me and I'll try to get the answer for you. Susan has a question about bathrooms. Is a bathroom with one stall and one sink considered a single-use bathroom? The answer is yes. If it has one stall and a lock on the door, it's considered a single use. Where it wouldn't be a single use would be if you walk into a bathroom at a company and there's a urinal and a stall and there's no lock on the door. There could be a lock on the door, but if there's a urinal or a stall or there's two stalls, it can be gender specific. Yeah, transgenders for everybody. Lorena said, thank you, Michelle. Can you let us know when where you're getting your posters again? Yeah, we're getting our posters from California Chamber. If you go to Cal Chamber or HR California, the posters are there. You can get them laminated or not laminated. I want to say we just got ours laminated. It costs $79 a year. We're on automatic renewal, so every year we automatically get the updates. There's also other companies. If you Google, federal state poster, you'll get other companies, but we just happen to use Cal Chamber. Minimum wage for 20 employees, full-time, part-time. The minimum wage laws are for everybody, whether you have 20 employees, 5 employees, whatever. The minimum wage is for full-time and part-time. Brent just checked and said that Westlake minimum wage follows California law. So if a door to the bathroom doesn't lock, but the stall does, one person can be in the stall and one person can be at the sink. That's a great question, Susan. I don't know the answer to that one. That is a great question. My guess is, and here's my guess, and I'll check for you, Susan, that you're going to have to put a lock on the door and make it gender neutral. One stall door with a lock. I'm making a note right now. One sink, no lock. And I'll get that checked out for you. So I have to get back to Susan on that question, and I'll get back to Jeff on his question. And any other questions? Someone else is typing. On our pay stubs, we show the effective date of pay for the period. You're supposed to have the beginning and ending dates of your pay period. So if it has the beginning and ending dates, you're fine. If not, I'll go back to the slide on that. Here. Inclusive dates, start and end dates. That's what they should have. If your bathroom has one stall and one urinal, it's not considered a single-purpose restroom, and therefore you don't have to make it gender neutral. I have one more person coming on board with a question. Maybe not. Okay. Then I think we're done with questions. Thank you very much, everyone. We'll get everything out to you in a week or so. Thanks for attending. One thing I'll make a note of is next month we're having a webinar on the second Wednesday at 10 a.m. again on employee engagement and morale. It's being done by Karen Bublis, who is an HR consultant and president of the Woodland Hills Pirate Chapter, and Robert Grossman, who is a business coach and leadership development employee management guy. And he's going to be they're going to do a joint webinar on employee engagement. One of our people, Barbara Archer, saw them do it in person and thought it was great, and they've agreed to do it next month. All right, thank you very much. Have a great day.